States, the great state of Florida, and the solemn report.
Please be seated. We have 3 cases on the docket this afternoon. We will take them in the order that they appear. After the first case, we'll take a break for coffee and invite you to join us in the Commons for coffee for about 15 minutes. For all appellants, if you want rebuttal, let me know. I'll try to remind you, but ultimately, you're going to be responsible because you have the clock in front of you. We ready on the first case? You may proceed.
May it please the Court, my name is Richard Suma. I represent the appellant, Ms. Cynthia McCoy. I intend to reserve 4 minutes for rebuttal. Ms. McCoy was convicted of the offense of trafficking and more than 4 grams of hydrocodone or a mixture thereof. Now, we understand that the trafficking statute generally allows prosecutions on multiple theories. In other words, it could be sale, it could be purchase, manufacture, and delivery. But a key point to remember in this case is that the state presented a very specific theory. The state relied solely on the theory of possession. Now, I find Ms. McCoy's conviction disturbing on a number of levels, but our primary contention is that the trial court erred in denying her motion for judgment of acquittal because what we call an affirmative defense of the prescription defense was proved as a matter of law at the end of all the evidence. How is it proved as a matter of law when she had in the same pill bottle 2 different colored pills? When she's asked about whose pills they are, she says her husband. She tells 2 lies about where her husband is. I mean, isn't that all inconsistent with the affirmative defense that I was really legitimately carrying these from my husband? No.
Okay,
I'll address the first one. 2 different colored pills, blue and green pills. Okay, the law officer found her. She did not deny that she possessed the pills, that they were prescribed for their husband. The pill bottle contained 2 different colored pills. The law enforcement officer himself said he reviewed his pharmaceutical guide or whatever they call it, and he discerned that the pills, both the blue and the green, were exactly what was indicated on the bottle. Now, our motion for judgment...
How many times have you've been to the drugstore and gotten a prescription and gotten 2 different colored pills in the same bottle?
Oh, we don't... Me personally, it's not relevant, but...
I understand, but, I understand there are 2 brands.
Yeah, but the point is...
prescriptions are not filled with 2 brands, are they?
But I'm arguing the denial of the motion for judgment of acquittal after the presentation of the defense case. Now, there are certain facts that came into evidence during the defense case that I claim must be accepted as true because they're perfectly reasonable, unrebutted, and uncontradicted, a rule which this Court adheres to faithfully.
Okay, well, help me again. Didn't she also make, if you believe the officer, didn't she also make the statement that she was taking the pills?
Well, as couched in the terms of the prosecutor's question, as incriminatingly as it could be possibly couched, yes. But now let's look on her presentation of her case. She said she told the officer, yeah, I sometimes have taken the pills, but they have been prescribed for me from the same doctor.
Well, she has 2 statements. She has one statement where she said, I've sometimes taken my husband's pills. And then she has another statement where she says, no, I've taken the pills that were prescribed by me. Isn't the jury entitled to look at that and determine which one of those statements is the truth?
Yeah, yes, Your Honor. In an ordinary case, inconsistent statements give rise to a jury question. But in this case, those inconsistent statements do not pertain in any way to the fact that the prescription defense was proved. In other words, these statements, these contradictory statements, let's take, for example, that she lied about her husband's location. Okay? That's a given. First of all, the elements are not in question. We admit that the elements were proven. So the only question is, does that lie mitigate or somehow undermine the proof of the defense? And the answer is it does not, because it's simply not relevant. lie about her husband's location, that has no bearing against whether she obtained...
Why doesn't that have a bearing on whether she was legitimately holding the prescription for her husband? Because let's even take her statement as true. If her husband is in Miami or wherever she was talking about down in South Florida, what business does she have carrying around his pills?
Well, Your Honor, I feel I must caution the court. If you want to go down that road, that's a very dangerous precipice to leap off of. Now, so you're saying...
Explain to me why I'm almost getting hurt here.
Because that's no different than, suppose a person has a prescription and they leave it at home and they go off to Miami. Does every relative who remains in the house thereby become guilty of trafficking in hydrocodone? Well,
there's a difference between that and putting it in your pocket and then getting on your bicycle and driving around town.
He may leave, if a person leaves town, they can take what they need and leave the rest behind. And does that mean then any person who's not the patient, who has that prescription in their household, is now guilty of trafficking?
Not as a matter of law, but isn't that a fact for the jury to consider?
No, Your Honor. No. Because if that were a fact for the jury to consider, then I would say you're adopting the argument that was provided by the state in their final rebuttal argument. They said, everybody's guilty, but leave it to us, to the discretion to know when to prosecute and when to not prosecute.
That's why I think you might have a better argument on your failing to give the instruction.
Well,
and also ineffective assistance of counsel.
That's my alternative argument, but I firmly believe that none of these disputed facts undermine the prescription defense. And we say, according to...
Okay, let's move on to another point.
Okay.
Let's move to the failure to give the instruction in fundamental error.
Mm-hmm.
Clearly, if you fail to instruct on the element of the crime, necessary element, it could be fundamental error.
Yes.
Martinez, at least in some dicta, seems to indicate that that does not apply to affirmative defenses. Can you discuss Martinez in your
Yes. Well, actually, Martinez, I think, clarified the law for us somewhat. That prior to Martinez, there had been a dispute. Some cases said, as a matter of law, it cannot be fundamental error to fail to instruct on affirmative defense. But Martinez, and I don't believe it's dicta, I think it's part of the holding of the case, they clarified for us. Well, if the affirmative defense is your sole defense, as it was in this case, and if there's evidence to support your affirmative defense, as there was in this case, then I think Martinez says, then the error is fundamental. And a subsequent case interpreting Martinez, which we cited, the De La Hoz case, says exactly that. If the element, or if the affirmative defense is 1, in dispute, 2, was the sole defense, 2, was supported overwhelmingly by the evidence, or supported by the evidence, I say Martinez says that means you have been deprived of a fair trial. In this case, there's one more factor. You have the additional factor that the prosecutor in closing argument specifically said to the jury, there is no defense. There is no prescription defense. So, admittedly, defense counsel failed to object to that, as well as the fact that defense counsel failed to request an instruction on the prescription defense. Now, the failure to request that instruction on the prescription defense, I believe there can be no reasonable tactical purpose for failing to request that instruction. The prescription defense was the only defense that was presented. There was ample evidence to support it. Not only that, the trial attorney argued the prescription defense on the motion for judgment of acquittal. With all those things being true, how can there can be no possible, reasonable, tactical explanation for failing to request an instruction on the prescription defense. And while there are a few cases on the matter, there are at least a couple that were out there that counsel could have relied on, and we cited the O'Hara case and the Smith case. So clearly, based upon the statutes that are available, there is a prescription defense. It may be true that the precise elements of that defense are not clear because there haven't been many cases. I think there haven't been many cases because this prosecution is thankfully rare, but I think should never occur. But it may remain for case law to flesh out exactly what are the elements of the prescription defense. But O'Hara recognizes it and Smith recognizes it, and counsel should have requested it. So I think it was fundamental error in this case for the trial court to fail to instruct on that prescription defense. I'll save the rest of my time for rebuttal.
Thank you.
Good afternoon. May it please the court, counsel. I'm Tom Duffy. I'm here on behalf of the state. Credibility was an issue in this case. Credibility is settled by juries and not by judges. The only way to have this be a JOA issue is if that defense was a perfect defense, as I believe was argued in the initial brief, at least, and it is not a perfect defense. There are circumstances that come up.
You agree there is a prescription defense, though?
Well, we didn't for purposes of the brief because I wanted to think about it some more, but it appears that is certainly a valid defense that can be given in the proper instance.
And would you agree that would cover, let's say my wife takes medications, and one of them is a controlled substance. Would you agree that if I went to the drugstore and picked up a prescription for her and got stopped on the way home, that I would not be, and an officer saw the drugs on the front seat of the car, that I would not be guilty of the crime of possession of a controlled substance?
I doubt seriously you could ever be found guilty on those facts. And here's why. If the prescription defense does not apply to me as her agent, then why aren't I guilty? You say you doubt I could ever be found, but why, as a matter of law, am I not guilty? I think what you have to look at that part of 893, and I've forgotten exactly what section it is, 893.13.6a. I think you have to look at that as applying only in cases where there is not some innocent explanation given. In other words, you've got an innocent explanation. You're driving this home for your wife. You can go home, show it to her, assuming a police officer would ever do that.
Okay, didn't this woman have an innocent explanation? I understand her credibility was somewhat damaged by the fact that she gave inconsistent statements, but at trial, both she and her husband said she carried this because he did not have pockets in his mechanic's uniform, that she carried his valid prescription for him. Okay, let me take you down this road a little bit further and then let you answer the question. My wife and I go out in the evening sometimes. She doesn't always like to carry a handbag. She asked me to carry some stuff for her. So she doesn't, because she doesn't have any pockets and she doesn't want to carry a handbag. Would I be guilty if I was carrying her prescription for her?
If you take a hyper-technical view of it, yes. Just as if I cut across my neighbor's property, the corner of my neighbor's yard to get to the mailboxes we share, I've trespassed. But that's not really a realistic expectation that anyone would be prosecuted for innocent possession at that time.
So it's up to the arresting officer and the prosecutor to sort that out.
Well, the way the statute reads, that is, that's certainly advice.
It's their call.
I'm sorry?
Under the statute, it's their call.
Well, it certainly would appear that way, and we have to assume that people are going to be reasonable. We have to assume that nobody's going to say that, and the officer...
Well, do we have to assume the prosecutor in closing argument is going to be reasonable? Because it seems to me here he argued there was no prescription defense.
Well, that gets us into another issue.
Well, it's the same issue because he argued even if he was holding this for her, that's not a defense. I mean, that's basically what he said in closing argument.
Yeah, that did not, however, I think, in light of things, mislead the jury. First of all, what he said was, you're not going to hear an instruction. And the reason you weren't going to hear an instruction is because no instruction was requested. So that part of it was true.
Whoa. Let's not believe that. Technically, it's true. They weren't going to hear an instruction.
Mm-hmm.
But aren't we being a little hyper-technical? Isn't what a prosecutor is saying when they say to a jury, you won't hear an instruction, that that is not the law? Isn't that the only reasonable interpretation of what the prosecutor is saying?
No, I don't think it is. I mean, you can read that. Of course, we weren't there, and we don't know what the tone of voice was, not necessarily always sure of the context. But what he really said there was that under these circumstances don't give her a defense. That's not a defense to someone who's not the prescription holder. The only two cases...
Okay, what about when he talked about the arresting officer, said he gave her every chance to get out of it. Tell me where your husband is. Show me that you need to be holding these pills for him.
Yeah.
So is it the state's position that she was required to provide her explanation to the arresting officer and then she would have been okay? Or could she, like, Judge Wolf's very experienced in legal matters, and he might know that once it's apparent that you're about to be arrested, that the less you say to the arresting officer, the better off you are.
But that's not
the fact that he didn't give an explanation to the arresting officer and he waited to come into court to give his explanation?
She was not under arrest at the time that she gave that explanation. So there's no, if you're trying to get a Miranda issue, I don't think that exists.
Is it ever required to submit your justification to the arresting officer, or you're stopped from presenting it in court?
No, and she wouldn't be stopped from presenting it in court. But that was the explanation, and I think that's what would happen if we're going to have this statute.
Mr. Duffy, I'm going to interrupt you because I was looking for something before.
Okay.
I want to read you two statements. One appears on 127 of the record and one appears on 131. Mm-hmm. And you just said that the prosecutor said you won't hear an instruction, but listen to this. They want you to say, so what her husband's pills, of course, she can have them. But you know what you won't hear? When the judge reads you the law, you won't hear that she had a right to have them because, after all, hydrocodone is a controlled substance. It seems to me what the prosecutor is saying there is that you're not going to hear the law that she had a right to have these because that's not the law. Not merely that the judge isn't going to instruct on them, but the judge reads you the law and you're not going to hear about this. Then he goes on, you will not hear from the judge that if a defense for this defendant to have the pills because her husband has prescription, you will not hear that. If you do not hear that, then there is no defense in the law for this defendant to have the pills. So it seems to me the prosecutor is going here one step further than just saying, you're not going to hear this instruction. He's saying you would hear this instruction if that really was the law. So isn't he making a misrepresentation of the law?
Well, I'm not sure he is, because it is illegal to possess a controlled substance without being the valid prescription holder. That's the technical...
So you just said that. Then the examples I gave you earlier about picking up my wife's prescription at the pharmacy, or me carrying it for her when we're out together at night, that I have broken the law. I've been in possession of controlled substances.
Under a technical, strict reading of this law, I think that's what the legislature said.
Well, counsel, you just said that you were talking about a prescription being held by a valid prescription holder, and that's not what the law says. And in fact, if you look further in 893, a pharmacist may dispense a controlled substance to a patient or an agent of the patient.
Correct.
But
taking that, Judge Rowe, that shows the circumstances under which I think that was meant to be only under innocent circumstances. And the problem with construing the statute to construing that part of 893.13.6a as...
Excuse me, before you leave that, you say only under innocent circumstances. If you believe the husband's testimony here and the testimony of the defendant, wouldn't that have been an innocent circumstance?
Had the jury believed that, they would have found her not guilty.
And if
they didn't believe it because it wasn't credible.
I would agree with you 100% if they were instructed that there was, in fact, a prescription defense. They were never given the opportunity to even look at that.
And the prosecutor telling them that that was certainly not a defense.
I'm not sure as to someone who is not the valid prescription holder and who is not acting in an agency as an agent at the time. I mean, you go to shut-ins. Somebody has to go to the drugstore and get a shut-ins medication. No one would ever be arrested for that, and I think you could argue that on the agency thing that makes at least gets the pharmacist off the hook for giving something to a friend or someone, if the person who's going to take the medication gets, is unable to get that medication themselves. But that's not what happened here. It is what would probably be happening in your situation that you described, Judge Wolf. You're on the way back from the pharmacy with the medication. Your wife asks you to hold her pills. Now, if she went off to Miami and you were still holding her pills, I think that it's a little tougher for you in that case. Because those are the
Judge Wolf's
circumstances.
wife called him and she was over at our office and she needed her pills and couldn't leave for lunch. And Judge Wolf was going home for lunch and he picked up her pills and drove them back to her. He's not coming from the pharmacy. He's just going to the house.
But he is acting as an agent.
Mm-hmm.
And I think that may be the key to this, because we've actually batted this around a bit internally, because there hasn't been much case law on it. But the point I want to make that is if you construe it in the way that it becomes a perfect defense, then the application...
Well, the jury was told here it really didn't matter whether the defendant here was acting as an agent or not. She had them, and they were controlled substances. That was the trafficking amount, and she's guilty.
She is guilty because there is no innocent explanation, or the jury didn't buy her plausible innocent explanation.
They didn't buy it.
They
How do
were
we
told
know
they
they
were
didn't
not
buy it?
allowed to buy it.
Yeah, how do we know they didn't buy it?
Because it was argued to them. They heard that testimony. They heard the argument from defense counsel. That was the thing. These are my husband's pills, and I was holding them for them. If you want to look at it from a civil law standpoint, they didn't prove agency. Now, I know it wasn't submitted that way. Well, a point I want to make is that if you take it as a perfect defense, where there's any prescription medication that's been validly prescribed, then it can't be, you could never traffic in such a thing by possessing it. And I think that's the gist of their argument. I think that's what they want you to accept. I don't think that's what the legislature intended here.
Well, I'm not sure I understand that.
Well,
Don't you have to show there's a valid prescription issued to someone?
yes, a valid.
Don't you have to show a relationship between the defendant and that person in order to be entitled to the prescription defense?
I think you ought to have to, but there's nothing in the law or in their argument that suggests that you would have to, that's the case.
I thought they did make that argument, but I'm saying to you right now, if we held that you had to show there was a valid prescription, that you had to show there was a relationship between the person holding the pills and the person who got the prescription, if you showed that there had to be some kind of agency relationship, which at least arguably there was here, what's the problem with having a prescription defense along those lines?
I don't see any problem with it, as long as it doesn't become a JOA. If the jury can decide that, no, we don't believe that she was acting as an agent
Okay,
in
let's
this
get off
case.
to point one.
Okay, point two.
Keep on going back to the judgment of acquittal. I'm just looking at point 2 and 3 now.
Okay, well,
What's the problem with that defense, and why shouldn't the jury should have been instructed in that manner?
had the defense requested it, I think it's possible that the judge would have given it. The argument against it is it wasn't presented, it hasn't been presented with these agency principles that Judge Rowe came up with or mentioned here. It was presented, I've lost my train of thought here. The difference between this case and O'Hara and Smith, and I think this goes to the ineffective assistance of counsel claim, is that in that case it was the prescription holder who was raising the defense. Had Mr. McCoy been caught with these things, and he says, my valid prescription here, I think that case he can raise it, but I don't know that necessarily what the legislature intended unless we can extrapolate the thing from the agency principle that's present in the statute concerning pharmacists. Then I think that in that case, maybe it could go to family members, but the way we see it broadly, it could include thieves. If you stole it from somebody, as long as what put it in the stream of commerce was a valid prescription, then it's okay to possess it.
I don't think that anybody's making that argument, Mr. Dillon.
Well, that was the fear, that was the slippery slope argument that we wanted to make.
I didn't recognize it because I didn't even know it was being made.
Okay.
And I'm sorry.
And we ask that you affirm the judgment and sentence below. Thank you.
Well, I feel the major problem with this prosecution is crystallizing fairly well. The state points to facts which they tend are incriminating. The problem with that is that under the state's theory of prosecution, the appellant would be guilty even if those facts did not exist. According to the state, the law says that she possessed it. It was more than 4 grams. She's therefore guilty. It's hydrocodone. She's therefore guilty. Now, okay, it may be unseemly that the appellant lied about her husband's whereabouts. That is fairly tangential to whether she actually obtained possession pursuant to a valid prescription. It may be unseemly that some of the pills were blue, some of the pills were green. But what about the explanation that was given and was uncontradicted? Is that not reasonable? I get a prescription every month. I bring them home. I put them together. The pills may be green or they may be blue depending on where I get them. We take a few out of the jar. My wife is carrying them for me. I'm working. My hands are dirty. I don't want to hold them, so she holds them for me. That's not unreasonable. She says she used the pills herself, but she's charged with possession. She's not charged with stealing her husband's pills. So I think those facts, which in an ordinary prosecution under the law may seem to be contradictory, suspicious, incriminating, they bear no relation to the prescription defense. I would ask you to consider that because I would much prefer that the court finds that the trial court erred in denying the JOA because Ms. McCoy is in prison and she can't even get bond for a trafficking offense. So if it comes to a choice of remedies, I would strongly request that the court look closely at the judgment of acquittal and whether or not it was
even if the
orders.
law doesn't support denying the motion for judgment acquittal, you want us to grant it because she's in prison? That sounds somewhat like a jury argument or something pulling on the heartstrings of the court.
No, Your Honor, what I'm suggesting...
Isn't it more a legal argument what the remedy is?
No, Your Honor, that's not what I'm suggesting. What I'm suggesting is that the court look very closely before rejecting that argument to make sure that the court is comfortable that the trial court did not err in denying the motion for judgment of acquittal. That's what I'm saying. And before I sit down, I want to make one more comment to a remark that you made, Judge Wolf, when you said perhaps in this prescription defense there should be some relationship between the patient and the person in possession of this drug, because I don't feel the law requires that relationship.
You trying to talk me out of holding for you?
No. I'm just trying to talk you into holding even better for me. The law says a person...
Do I have to go there to help your client in this case?
Not necessarily. But if you don't have to go there, I'd rather not see that in an opinion. But I'm just trying to be precise and helpful to the court and saying that if it's not necessary to say there must be a relationship between the patient and the possessor, perhaps it's best to leave that alone. So, first, I would request that the court hold that the trial court erred in denying the motion for judgment of acquittal at the end of all the evidence. And in the alternative, I would ask the court to hold that the trial court committed fundamental error in failing to instruct the jury on the prescription defense. Thank you.
Court will stand in recess for 15 minutes. We ask everybody to join